So I welcome you, Praharsh Gour.
Thank you so much for having me. It's really a great honor for me to be here. I am a listener of your podcast. I have been following your work, and it truly means a lot that today I got a chance to feature on this.
How was your experience working with government actually?
It honestly, I can say for my department, my division that I was working with, and I figured out that it depends a lot on people that you are closely working with.
Tell me more about what is SpicyIP.
Mean, as you said, it started off as a blog. It was started by Professor Dr. Shamnath Bashir back in 2005.
How Indian Patent Office is going to work after this FTA?
So, like when we talk about FTA and intellectual property, they want a country with favorable laws, which is beneficial for their companies for the time to come.
Welcome to another chapter of Built on Brains. Today with us we have a researcher, editor of SpicyIP, who has 7 years of experience in this industry. He has also worked with Ministry of Commerce and Industry as a senior research fellow, and he is continuously writing on various things on SpicyIP, which keeps us on track what is happening in this Indian IP scenario, whether it is policy changes, whether it is FTA, or whether there are any case laws that are upcoming. So I welcome you, Praharsh Gour, for giving your time on this podcast. So Praharsh Gour will give his own understanding, irrespective of what Spicy IP represents. So we are talking him in person to understand what his thoughts are. So I welcome you on this podcast.
Thank you so much for having me. It's really a great honor for me to be here. I am a listener of your podcast. I have been following your work, and it truly means a lot that today I got a chance to feature on this.
So before starting, would you like to brief about yourself? So what was your personal journey? How you came into research? In spite of being a lawyer, you tend to write more. So what was the story all behind this?
Okay. Yeah, sir. I mean, so I like to believe that everything that happened with me is a happenstance, which means that when I got into my law school, I wanted to get into academia. Both my parents are professors. My sister is also a professor now. She's based in US, and I thought that I'll follow the same journey. And I remember that during my orientations, introductions in my law school, people would ask about what do you want to be, what do you want to achieve after you are done with your law school, and everybody would say that they want to join a law firm, they would want to practice, and perhaps I was one of the very few people who would say like, oh, I want to join academia.
Okay.
I knew that I wanted to join academia, but I wasn't really sure. Acha, theek hai, like what to do, like what am I going to teach?
Mhm.
And after a first set of semesters, I was not really sure that I'm able to find my calling, I was able to find my area of interest. And that's when I read about Professor Shamnath Bashir. He had recently quit NUJS, and he was all over the news that there is this rock star IP professor who went against the administration back then for so and so reasons. And then that got me interested into, acha, theek hai, let me look him up, who this person is. That's when I got to know about IP. That's when I got to know about IDIA, and from there, it kind of hit me that okay, I want to work with this person first to figure out how I can become an academician. And
Mhm.
then, I had a couple of stints of internships with him. First in IDIA, where I worked with his team in Calcutta, and then directly under him in Bangalore. And that's when I met Swaraj Barua, who I consider to be a mentor and a very dear friend. So Swaraj and Professor Bashir, they were the ones who told me that all right, fine, you want to do academia, you want to pursue academia, you want to teach, but you need to be absolutely clear as to why do you want to do it. All right, you just believe that you want to do it is not going to cut. You need to have your clear reasons, which is a very basic thing to say, but I understand that a lot of people don't really understand. They
True.
just listen, they just figure out, acha, theek hai, this sounds interesting, this sounds cool, this sounds nice, and I do this. But to have your heart in the right place is perhaps the most important things that you need to focus on. From there, I thought that I'll get some practical exposure. Then I started working with Intel Advocare for like close to 1 year. That's when I met Mr. Wasim Shoaib Ahmed, Anandya Tiwari, and other folks from the team. And due to some personal tragedies, I had to put in my papers, move back to Raipur. And then after things were better, I decided that all right, fine, now is the time when I should go and pursue quote unquote academia by pursuing my masters.
Okay,
So
okay.
this thing was going on in my head, but I was still not sure like how I need to do it. I had some idea, but I wasn't really sure which quote like proper area I need to work on. And as you said, that I was a lawyer who was transitioning, or who had this, what should I say, this junoon of sorts, that I want to do this, but
Something different.
without any, yeah, without any idea as to how I can go ahead. And that's when I met Professor Prabhash Ranjan
Mhm.
in South Asian University. He was my guide there. He was one of the professors who taught us there. And that's when he told me that, all right, fine, you know what, there is this area of trade and IP which I think you should pursue if you are interested. Since you're interested in both these subjects, since you're opting for all the correct papers there.
Mhm.
And then COVID hit, and I was again not sure like who is going to guide me, who's going to take me forward. And that's when Swaraj came back again in my life. I started working as an RA for him.
Mhm.
And then I realized कि, okay, theek hai, like I'm not really sure if I want to quote unquote teach, but I'm sure that I want to write more and I want to contribute through research. And that's when I decided that I'll join the area of research in trade and IP law. That's when Ministry of Commerce happened. I worked there for 1 to 2 years with some fantastic set of officers,
Mhm.
Mr. Prakash Kamble, Mr. Mithileshwar Thakur, and Mr. Anand Swaroop, who
Mhm.
was the DG at that point. And then I got a text from Swaraj saying that, all right, fine, Spicy IP is looking for someone to work full time with them.
Mhm.
Now, when I was doing my research about Professor Bashir back in the day, Spicy IP was one place where I would always think about, all right, I need to feature here, I need to write something for this platform.
Mhm. Mhm.
And then I got this text saying that, all right, fine, you can work here full time for the rest of your life if you want to do that. And that was just a dream come true for me. Like a lot of people think about joining big law firms,
True.
working with big top names in the litigation circuit. For me, this was my dream come true. And then, without any hesitations, I spoke to Swaraj,
Mhm.
tried to figure out a couple of details, and then yeah, decided that this is it.
True.
So I am not sure if you're looking for I'm sure you're looking for a very short and sweet answer, but this is what my whole journey is about. And as I said, that I believe that this is all a happenstance, and I'm really glad, and I'm just uh, going through it right now as well.
I think so. You are fortunate enough to figure out your callings at very early stage of your life. I can say some people still figure out, or they are still trying to figure it out at the later stage of their life as well. And when you get into some profession, initially first few years are good. If it is not calling, even if you don't, it's not your calling per se. But later on, you start questioning yourself, ki, what am I doing and what I was supposed to do. So it's good to get into that what you like. So with this, I wanted to add one more question. How was your experience working with government actually? So
So, sir, I mean, it honestly, I can say for my department, my division that I was working with, and I figured out that it depends a lot on people that you are closely working with. I could see that there were a lot of people who were not really able to extract the most. They were not really able to get out the most or make the most of the opportunity that was given to them. But I was fortunate enough that I got to work with DGTR under like fantastic set of officers
yeah.
who from day one, like I remember there it was my first or second week in the job. I think that I made a mistake, and I went to my senior and I said, ki, like, sir, I think I made a blunder. And he said, ki, all right, it's okay. There is nothing that cannot be fixed. We'll figure it out. But do not lose your calm. Do not like make it so bad that it gets into like it results into a domino effect and something that we are not really able to repair later on. So it's okay. People make mistakes. It's fine. Let's get back to work and we'll figure it out. So that sort of assurance, that sort of comfort that was given to me there, I really think that not a lot of people understand that people in the government are working under immense pressure, and they need to keep their head cool. And especially my division, so I was working for the viewers. I was working with Directorate General of Trade Remedies. Now, what trade remedies are is basically they are these duties that the government imposes to offset the difference between any product which is available, which is imported in the country at a relatively lower cost. So I mean, to long story short, let's say there is this product which is manufactured in a country where they are able to manufacture it at a lower price. So they'll produce it in a large capacity. They'll export it to, like, let's say country like India, where that product takes a little high, like it's being produced at a little higher cost by the domestic industry for whatever challenges there might be. Okay. So in that situation, there is a dumping that is taking place, and to offset that price difference, them being able to manufacture it in a at a cheaper price as compared to India. To offset that difference, the government imposes these anti-dumping duty. Similarly, sometimes we hear these things called subsidies. Government may give subsidies to companies because of which they are able to manufacture a product at a cheaper rate. They are not able. They may not pay certain charges that the government usually levies. And in that case, again, the government of the importing country, in this case India, would impose something called a CVD duty, countervailing duty.
Okay.
Now, Directorate General of Trade Remedies is a quasi-judicial body, so to speak, which conducts investigation both from an accountancy point of view and from a legal perspective, because there are set of agreements by WTO where, and after conducting this investigation, they pass their finding. Now, interestingly, I was working in a division within this department where I was supposed to represent Indian exporters before authorities abroad.
Okay.
So, I would be working with top-notch law firms, and helping the government slash the exporters and the law firm to come up with best responses. Which means that I would reach out to different departments. My team, like not my team, but my department would reach out to folks or offices in different parts of the country, asking them details about अच्छा ठीक है आपने कितना subsidy दिया, what was if there was a subsidy that was given, what is your take on this thing, so on and so forth. We'll collate all the information, we'll collate all the data,
Uh-huh.
and then we'll share it with the law firm to prepare a response. This law firm would be impaneled by the government to represent us formally, and then we'll submit our response before the investigators. So my role here was to assist the government in terms of preparing the best responses along with the team of lawyers that are impaneled.
Okay.
So it was a wonderful experience. As you could see that I was there in the middle of a position where there is a lot happening, and I could get like the front row experience to figure out, all right, fine, how are these things taken care of? How import and export matters are taken care of.
Right, right.
So yeah, I mean, it was a wonderful experience that I had back when during my time in DGTR.
You said wonderfully that from outside people think that a government job is good enough, or maybe there are a lot of perks and time advantages that you have, but you have mentioned that there are a lot of constraints, that there are a lot of pressures, there are a lot of work related pressures that government people handle. Many people don't know about it. So good to know about you and how you represented the Indian exporters.
So, I mean, I would say that it wasn't just me. I mean, of course, I was a very, very small part of the large team comprising of top-notch officers and best legal minds in trade law in India. And
Part of it.
I was basically learning from them. I'm not sure if how I was able to contribute, how much I was able to contribute. I was able to learn a lot. So, yeah.
That's wonderful. That's wonderful. Being a part of a team which is representing Indian traders, it's not a small thing, I can say. And good. There are many things that you can learn from not only Indian people but also a lot of good things from foreigners as well, because they are little way ahead than what we think, as per my knowledge, I guess. Great, great. So coming back to now, spicy IP, as you mentioned, it was your passion, and you got an opportunity, you got a call, and then you said yes because this is what you wanted to pursue. So, so overall, can you tell me more about what is spicy IP? We know as an external person, we just know that it is a blogging platform where we get all recent updates within a day's time, a couple of days time, and that is where we are also following Spicy IP, reading Spicy IP content extensively. I hope all the IP fraternity will agree with this because we get
I hope so too.
very soon on the Spicy IP. Before we think of writing it, we already have an update on Spicy IP. So,
Thank you. That means a lot, sir.
just, can you tell me what exactly is this platform and how it was started way back? I think so, 15, 20 years back it was started, right?
Yeah, 2005, I think. Yeah, 20
Yeah,
years.
years back. So that time I also started my career in IP.
Oh, okay.
Yeah, just can you throw some light on that?
Sure. So, sir, I mean, as you said, it started off as a blog.
Mhm.
It was started by Professor Dr. Shamnath Bashir back in 2005.
Mhm.
There is this interesting story that we like to tell. This is available on the blog as well, and this is how we recall how the Spicy IP journey started. It was back in 2005. I think Professor Bashir was somewhere in the States, and he was like he I think he was sharing a room, or he was in close proximity to this one gentleman who was either a police personnel somewhere in one of the Southeast Asian countries, or was related to enforcement in some measure. And then there was this guy who was, and that person was, typing something like a man possessed, and he was like really excited and really into something. And Professor Bashir went there and asked him, ki, like, all right, fine, what are you doing? What is like driving you so hard? And he said that, oh, this is something that I've started doing. I'm blogging right now. And
Mhm.
that's when they're like, "Ki, okay, fine, that's when it kind of came to him, ki, in India back in the day, there were very little platforms, news outlets, which would report things on intellectual property as they are. And 2005, as you would know, is a very important year for India because of all the trips and other related stuff. And that's when he realized कि, okay, ठीक है, like there are these platforms which report on IP developments, but
Mhm.
often they would just they would misreport things. So like let's say there's a trademark infringement matter, and they would report it as a copyright infringement matter, or a copyright infringement matter ko they would say a patent infringement matter. So all these nitty gritties were not clear back in the day.
Still, I can say, still, if I read newspapers, if there is a GI, even if it is a trademark, they will by default use it as a patent. So
Yeah, yeah.
recently, a couple of years back, just I want to highlight these things. There was a big newspaper in Maharashtra which stated that Nasi grapes got patented, but it was GI.
uh, yeah,
And still there
yeah,
is a lot of uncertainty, or less clarity, I can say. There is a lot of scope of improvement for this media
yeah.
people to cope up with what exactly it is. So you're right, so you can please go ahead.
Absolutely. I mean, so sir, I mean, just to add on to this, very recently, the whole Jagannath Dham controversy that is taking place between Orissa
Mhm.
and West Bengal, a lot of media outlets reported it to be a copyright matter or a patent matter, a trade. Like they were not really clear as to which specific IP is under question there. We did put out a post on it,
Mhm.
I think last week, by
Mhm.
Subbalakshmi Mukherjee. So, like, yeah, again, this is a small self plug here for viewers to go and check that piece out if they're interested. But to add on to that point, yes, sir. I mean, this problem is still there. A lot of the media outlets are not really able to like do correct reporting when it comes to IP matters. I would say a lot of them, the situation has definitely improved, but then again, there is a lot of things that still goes on, which is quite problematic. So coming back to the Spicy IP journey, this was the motivation that one was incorrect reporting, and second was, you would all know that especially patents, they are very technical in their nature, like patent litigation. To understand the nitty gritties of patent law, it was very technical, and there was no platform which was there back in the day to explain it or to break it down to the bare basics for the readers to understand as to what exactly is happening and why this is important for them, how it is related to their day to day life. So these, I mean, as far as I could recall, because again, 2005, I was, I think, in class five. So that's when Spicy IP started. But, when I would look back and I would read the blog posts, these were the motivations which kind of resonated with me the most. And that's what I like to associate that, these were the reasons why Spicy IP came into being. I'm sure there are a lot of other things there which more senior people from the blog would be able to, tell and share. But yeah, so Spicy IP started off as a blog, and then over the years, when Professor Bashir was still with us, it was working as a blog, as a platform where people would contribute to the best of their ability. Whenever they would have some time, they would share some inputs. They would share some other information. We would also organize some conferences in association with Spicy IP, Conciliance 2016, with Analyst Bangalore being one such example. And there are many other things that Spicy IP would help in organizing in terms of spreading the discourse on IP law in India. And then in 2019, when unfortunately we lost Professor Bashir, after that, Spicy IP was being run by a set of like people from the team, and we would still have like law students coming in and helping us out in form of occasional bloggers and analysts. And in 2021 or 2022, that's when we like this Spicy IP evolved from being a blog to a public charitable trust. And today, today we Spicy IP is registered as a public charitable trust. And apart from writing, apart from the blog that we have, we recently organized our first edition of Spicy IP Summer School. We also work, or rather look out for collaborations with academic institutions to work on a specific research question or to prepare some reports. We comment on rules that are published by the government, share policy suggestions. So yeah, I mean, trying to move out, if I can say so. I mean, of course, that's the thing. Like, I'm
Fine, fine.
slightly struggling with this answer because Spicy IP was not just a blog from the get go. It started off as a blog, it kind of became something big, and we're trying to just make sure that it becomes bigger. I mean, on a lighter note, I would say that I'm sure a lot of people would have seen this movie Welcome, and
Welcome.
when somebody asked Nana Patekar or Anil Kapoor, what do they do, and they said like बहुत फैला हुआ business है हमारा. That is something that I would like to associate. Like, you know, it started off as a blog, but then there is a lot of things that we're trying to do and we're trying to work on. Yeah.
Okay. And one more interesting thing is there are quick updates. So how Spicy IP manages to keep all so quick?
So, sir, as I said, ki, like Spicy IP is not just a handful of folks who are working with us on a on a tag wise basis, if I can say that, if it makes sense.
Hmm.
It's a community, I would say, where people from IP fraternity, they share their inputs. Our readers, our contributors, like fantastic set of support we have like fantastic support we have got from a lot of people. So they would share regular updates with us. Like, let's say if somebody is involved in a litigation, they got an order, they would share the copy of that order with us and say that, hey, this is interesting because the court said this and this. So we would have inputs from them, and then shout out to Indian Qanun for sharing updates regularly on an open accessible basis, because we see that openly accessible basis because we see that a lot of these databases are behind paywall where you're not able to access full copy of the judgments. But when a judgment is uploaded, Indian Qanun, being one of the few, other openly accessible platform that share a copy of the judgment out there in for people to read, and on an occasional surfing, yeah, you would get something from there. And then Google alerts, sir. I mean, so this feature on Google, that where we get any pings from any development that has IP associated. And then the team of folks that we have here, law students, PhD people, lawyers, who would just look out for all the developments that is taking place in different high courts. We would occasionally, regularly monitor all the judgments, wala pages from different high courts. Keep an eye out on the cause list. So yeah, a lot of work goes in there.
That's great to know because it's very interesting to read all the blogs that are there on Spicy IP. And now coming to FTA, actually, that is what the topic of interest is. It was a very interesting and confusing publication about intellectual property. So trade, geographical indication, they had some clause because Prada, there was a recent case of Prada where it was prominently highlighted globally. So I think so they included GI as one of the parts in that FTA. But they also revised this FTA, which was earlier version was it was, I can say, at a very different level. They came with a different version. So can you just throw some light on this FTA because you have gone through it, and I would like to hear from you more about it.
Sure, sir. I mean, I'd quickly explain where this whole thing is coming from. Usually, when you're talking about trade may, we have goods, services, and everything else. A lot of people would wonder, "Acha, theek hai, like, where is intellectual property coming from when you're talking about trade in goods and services?" And it was back in, I think, 80s when the whole negotiation was going, like negotiations to establish World Trade Organization was going on during the Uruguay round, if as far as I can recall. There was a strong push from developed countries to have
Mm,
uh, IP as a part of this large package of trade agreements to offer to different countries. So we had WIPO already there. There were talks of revising different agreements that WIPO was taking care of, and then suddenly US and other developed countries came up and said, "Ki, like, no, no, we want IP to be a part of this package uh, of different agreements that we have to offer as a part of you to become a WTO member." So,
okay.
that's how TRIPS came into being. And now, when we're talking about FTAs, a free trade agreement is an exception to the norm that is there in place. So, what
Mm,
the most favored nation, as a principle, what it says that when you are charging, like, let's say, a custom duty on a particular good coming from, like, country A, you cannot charge a
mm.
different rate to a different, like, to a different
Okay.
country. So you cannot,
Impartial.
yeah, you cannot have different rate of tariffs, so to speak, for goods coming in from different countries. But then there are certain exceptions within GATT which allows you to do it. There might be some national security concern, or when you are in a free trade agreement or a custom union. So GATT allows you to have this free trade agreement as an exception. Now, what free trade agreements, what they do is, it's usually a bilateral conversation between two countries saying that, all right, fine, you have these industries which are good, and you produce extensive, like, you produce that's where your what should I say, expertise lies in, and my expertise lies in so and so and so and so products or services. Let's agree that we are able to give each other some, like, a big market, a decent market for your product to be sold in mine, and vice versa. And then, there are negotiations where they talk on all the different chapters, all the different issues that may come up. So usually free trade agreements, the most, what should I say, the chapter or the heading that gets most of the traction are goods, because usually tariff lines are adjusted, as I said, that they are exceptions, so you can deviate from the MFN clause and give them a preferential treatment. But at the same time, everything is negotiated when you negotiate a free trade agreement. This is where the IP chapter comes
Correct.
in. So, an intellectual property chapter is a part of the bigger FTA, where they'll talk about all the different issues that country A may have with the law of country B, where they think that, it's
Mm,
not the other country's law is not suitable for their, companies. So let's say right now we are negotiating with US. US has been one of the biggest opponent of Section 3D and compulsory licensing provisions that are there in the Patent Act. Although the details
Please.
of the agreements are not out yet, but historically we have seen that USA has been imposing unilateral sanctions. They have been saying that India needs to change its course on when it comes down to certain flexibilities, including 3D and compulsory licensing. We recently had two FTAs signed, one with EFTA, which included Switzerland, and one with UK as well. The UK one was all over the news back when we wrote on it. So, they also have certain provisions which asked India to tone down some of its flexibilities, especially with regard to Section 8 filings and, pre-grant opposition, so on and so forth. So, yeah, I mean, broadly to explain FTA as a concept, this is what FTA usually means. This is how it operates. And, FTAs are signed after rigorous round of negotiations between both the countries, where they take into account what their realities are, what is expected out of them, and then they come to a common term. Now, you did mention that the final version of the FTA that India signed with the UK was completely different from what was originally out there. So yeah, it was the previous version was a leaked version, which anyone who's familiar with India's trade regime would know that most probably uh, the leaked version was the version which
Right.
was proposed, which could have been proposed by the UK, because it was more in line with their laws and their policies, and they were kind of nudging India to make those necessary changes. But kudos to the negotiators that they made sure that a lot of things would still in India would still be fine when it comes down to certain flexibilities, especially with regard to data exclusivity and completely removing Section 3D, so on and so forth. So, yeah, this is how usually the FTA negotiation and the FTA business works. Yeah.
Okay. So as you mentioned, when it comes to an FTA, there are these are the separate agreements which bypass the norms where we can have separate trade agreements, negotiations, and considerations based for the particular country, right? Now, when it comes to intellectual property, if there are some such kind of negotiations happening which are very specific to a particular country, will that affect that only the patents that are filed from UK, or it is going to change everything in India, or how Indian patent office is going to work after this FTA? That's a big question that I have.
So, sir, I mean, it would be extremely difficult to have an FTA ka provision with regard to patent applicable only on certain companies that is registered in one particular country. And by
Mm,
register, I mean they have their offices there. So for like when we talk about FTA and intellectual property, they want a favorable uh, treatment, a country with favorable laws, which is beneficial for their companies for the time to come. So what
mm,
I mean is, like, let's say if they say that a provision like 3D is not there in the UK,
mm,
hypothetically speaking,
yeah,
or in any other country, what they would do is they would say, "कि अच्छा ठीक है, you also get rid of this provision, so that the way the applications are examined is somewhat similar to what or how they examine how the applications are examined back in UK. But unfortunately, as I said, it won't be possible for you to only carve out an exception for
mm,
the
mm,
companies registered or coming from UK. So you have to
correct,
make changes in your domestic laws. So to answer
correct.
to your question, there needs to be a substantive overhaul of your patent act, patent rules, all the other IP laws, to incorporate some of the asks that a particular country might be asking from you. A big example would be something that is in discussion right now. So India does not have data exclusivity, but US does, and Switzerland also has a data exclusivity regime. So if you will take a look at the India EFTA FTA, the one which we signed with Switzerland among other countries, there was an annexure there which said that when it comes down to data exclusivity, the countries are going to come back to it after 1 year from the date since when this
Yes.
FTA is in place. And I think last week or last to last week, there were statements made by government individuals that we are trying to overhaul the patent law. We are also trying to look at if we can introduce a data exclusivity regime, naming that this is something that has been said by our trading partners, Switzerland and UK, that India does not have this provision or this setup in place. So there needs to be something done, and then they connected it with R&D. That's a different business altogether. We can come to it later on in the podcast, but respond to your question, this is how usually it works. Yeah.
Okay, okay. Because I see there are some recommendations that are good enough for Indian entities as well, because that may help positively, and there are some things that are okay, not so good enough, I can say. So, what is your comment on this? So, how it is going to affect Indian entities in long run if those changes have been implemented?
So, sir, I mean, it would be like from the looks of it,
Mhm.
from the amendments that were introduced, it would be very difficult for us to comment on is this is a India entity specific concession or a provision, and this is one which is made for like
No, no.
foreign companies.
I was asking
No,
in
no, yeah,
general.
yeah, yeah. So that's what to respond to that. Usually it is going to make things easier for the applicants, sure. Yeah, of course you won't have to file form 27, which tells as to whether your patent has been working or not every year. You have to file it once every 3 year, but you also have to understand what is it taking away from the larger public there in place, because form 27s, for the viewers, they need to understand that it used to give minute details of whether a particular patent has been worked or not, what is the unit of the product that they have imported, and the prices, the particulars that are there. So it tells sufficiently a particular government office and also the courts that whether a patent has been worked, or is the patentee just sitting on that particular patent and not really working it in India. Because if they're just sitting on it, then it gives you a ground to file a compulsory license to make sure that that particular product is being used in India and is available to the public. But since you only have to file it once every 3 year, these regular information updates which a particular patentee was supposed to make is not taking place in India. Similarly, when we talk about section 8, now section 8 would say that a
Sorry.
controller could ask for foreign information on foreign applications which are corresponding to the application filed by a patentee in India. Now, previously it was the controller who would ask, but now it has been shifted, and where as per the amendments in the patent rules, the controller has been said that, oh, you find out things according to your own, to the best of your ability. uh, and the impact of this particular amendment in that situation is that a lot of the times controllers do rely on what are the examination status, what are the objections that a foreign patent office might have taken on a particular invention, and then see whether it makes sense for them to do it in India as well or not. So basically a reference point. But now what was something a mandate has now been kind of taken away from the a flexibility has been taken away from the controller of the patent act. Similarly, when you're talking about pre-grant oppositions, again, it's going to make things easier for a lot of the patentees, which would say and go out and say, like, oh no, it takes a lot of time. There are these people who are not really serious about it, and they are just, making things difficult for us, for the applicants. But on the flip side, we can see that a lot of important life-saving drugs, pre-grant opposition would make sure that it acts as a barrier against evergreening. It acts as a barrier against people trying to get patents on, like, secondary patents on the same invention, bedaquiline example being one of the most recent ones. And it also acts as a lever for them to, for generics or other interested people to either drop that secondary patent application or license out their inventions. But now, with a lot of amendments which are made in the patent rules, things will get difficult for pre-grant opponents, and you won't be able to see these many interventions, which is there to aid and assist the controllers uh, working on these applications. So we do get it, like it would be a bit difficult to say that this is good for Indian patentees or applicants, overall, I think there are going to be implications which are going to take away certain flexibilities which were necessary for public interest, to safeguard public interest, owing to these amendments or these changes introduced by the FTA.
Okay. Yeah, as per my understanding, Section 8 or Form 27, these were harshly implemented because in case of any misouts, that was one of the grounds to revoke a patent application. It was against the patentee when it comes to litigation, actually. And second thing is when I for pharmaceuticals, it's very easy to understand कि भाई ये drug है इसका एक patent है. I'm selling so much units of this product and I'm running this much. For example, for manufacturing industry, I'm representing a lot of manufacturing industries. So filing a form 27, when, for example, I'm just giving you as an example, there is one device where hundreds of patents have been filed on that particular device. Now, what revenue has been generated from one patent or one technology, it's very difficult to figure out. And what they end up doing is कि total 100 पेटेंट्स का एक ही वैल्यूएशन हो जाता है. So they try to mention that this is the revenue that is generated by this 100 patents, and Form 27 will represent same thing in all 100 patents, for example, because it's very dicey, difficult to break down and calculate what exactly we are running. So that is from a manufacturing industry point of view. It seems to be giving little benefits because it's not that easy to mention what is the revenue actually.
Yeah, yeah. No, no,
And
I
the
get
second,
it. I get it. So I mean to add on to that, yeah,
uh,
there were these specific particulars which the government used to ask to make sure or to get an understanding of whether a particular patent is being worked or not. Now what they have done is it is being made into a tick box sort of regime. You don't have to give any details, you just have to simply say that yes, it is working. So you see, from being harshly implemented to it becoming a tick box regime of sorts, we are
that's true.
it's like a pendulum which is oscillating from one extreme to another extreme, and there is no middle way where there could be an arrangement which could work out both to ensure public interest and also to make sure that the patentees find it easy, if I may say so, to implement this flexibility that is in place.
Right. So, as I understand, correct me if I'm wrong, compulsory license, the rule that gives any applicant an opportunity to have a compulsory license is not only in India, but it is in multiple countries it's
Right,
applicable. But India
right,
was the first country to
right.
award compulsory license, though again into pharmaceutical sectors. In those countries as well, there is no as such harsh need to disclose the earnings from a patent. I see that is very specific to India. Sometimes it becomes little difficult to understand why parent office needs it. Let the opponent find it, figure it out, prove it in the court of law, and then from there it can take it, because this information is going into public domain. There is no restriction on this information, right? So that's what I think actually.
No, no,
May
sir.
differ.
I mean that is true. But if we look at it from again from a pharma perspective, I would respond to this, or just to add on to what you said. These things, the compulsory licensing regime that we have in place, it does not ask for whether the patent has been worked in India or not. It also takes a look at whether a similar mechanism can be taken place when there is an affordability question as well. When you are selling a product which is way too expensive for people to afford, and that's when you can seek a compulsory license as well, as far as my understanding goes. And
That's
this particular information used to address that question to the best of my understanding, that when you're talking about these specifics on prices, these specifics on on the figures, they do take into account that particular factor uh, through which a compulsory license is granted.
true, true. So we'll not get into compulsory license nitty-gritties, I guess. So there's a big topic to discuss in a separate talk we can have. Again, coming back to Section 8, actually. So this is also one of that is needed by very specific to Indian Patent Office. No other countries asks you to give all the details because they are very confident about their own examination cycle. right? And we need always a reference point. अगर India US में grant हो गया तो we will grant it. I don't think so that should give any benefits to the controllers, because that is that one of the reason what happens is that earlier now, from last 5 years I have seen there is a difference. But before 5 years I used to see कि whatever there is in if there is a PCT application or if there is a US application, same question, same citation used to come into our FTAs as well. Similar, I will say. Similar. So as a I don't know, but it's not good from an examiner perspective to just rely on what was happening in other countries. And another thing is now every information is public. Majority of the countries have their databases online public, and there is always a priority claim that we make whenever we are filing a patent application. And there is some miss outs where there are criminal charges also are leveraged according to the act, right? So in spite of having all access to this data, because I can understand before 2008 the system was closed, we were all doing book hardcore research in the libraries, checking all the documents and the classifications and all those things. Now, even Indian parent has gone digital. We have access to everything that is happening in India. Earlier, it was not there. But globally, the majority of the countries were all having good data online. So I don't know, means why again they need a validation from the parent applicant perspective and make him a defaulter for not submitting anything that has been updated. So, so that's what my understanding was actually.
So, sir, I mean, on that, I would like to say there are two things. I mean, you correctly pointed out that this is supposed to be a reference point. You cannot just copy paste and say कि like, अच्छा ठीक है, US में this happened, this is going to happen in India.
Right.
As while I was explaining this issue as well, it is
Right.
supposed to be a reference point for the Indian Patent Office. But unfortunately, we are in a time where, as you rightly pointed out, that we do defer a lot to the investigations which are conducted abroad and how the particular application is examined whenever a patent would be rejected, saying that, oh, see, my patent has been rejected on these grounds, but it was granted in EPO or like in by the US,
Correct.
in the US as well. So in that case, the plaintiff or the appellant is making an argument in on that basis, but I won't go there in the what happens before the high court. Coming back to the office of the Indian Patent Office, yes, I agree that it is supposed to be something which is supposed to act as a reference point. Second thing is, you are correct that all of these information are there, available online. But then I always feel that me as an applicant would have access to all of this information instead of asking the controller or the examiner to be like, ठीक है, आप अपने हिसाब से खोज लीजिए. I would readily have all the information available. It is going to be much more easier for me to share that information with them. So yes, I do get it that they should not be blindly relying on what all has been happening abroad. But again, if you refer back to the Iyengar committee report, which was talking about what the Indian patent regime should look like, that was it's there as well that they have mentioned that foreign applications ka benefit they have mentioned in their IPAB on numerous occasions when Justice Prabhat Devan has passed a couple of orders appreciating Section 8 levers, and where or how that particular information actually aided the examiner in a comprehensive examination of the applicant of the application. Now, one slightly off, I may go slightly off topic, but this is something which is important for us to understand as to why we are harping or why we should have a rigorous examination process in India. It is because if you take a look at what is happening in different jurisdiction also, they don't want later on in litigation that somebody would file a revocation petition against their patent, saying ki, like, boss, see, this order is like, it doesn't make sense, the patent is not fully examined and it should be revoked. If your patent goes through a rigorous check by the Indian Patent Office, it is bulletproof later on. So it is going to benefit you, the applicant, only in the longer run. So that is something that a lot of the people are not really understanding, and they just want to make sure that they get patent somehow and be done with it.
Yeah,
That's
yeah,
where the ball that's where the buck ends for them. Yeah.
right. So that small difference I would like to make. Indian Patent Office can definitely ask for such kind of updates, but they should not make this one of the grounds to revoke a patent application. That's the only difference I can put on, so that they are not been penalized so harshly. Like it's not good. That's what I can say. They can definitely ask for the details at the time of examination, at the time of hearing. Yes, but rejection on that grounds would not be a good uh, thing to do. That's what my understanding is. So thank you for your comments on also these Form 8 actually. So anything you want to elaborate more on this FTA that was there, which we can talk on?
So, I mean, yeah, the after explaining the whole FTA business, this is something which is very new, or rather, which is not very new, but which is in the news, so to speak.
Uh-huh,
It also
uh-huh,
gets important because what is happening in the broader trade regime, in a global space, where we are seeing that there is this 50% cut tariff which is being imposed by the US, and then India realizing that US is their biggest market, and that's when we are nudged towards getting into trade agreements or negotiations with different countries. The UK trade deal, people have actually attributed it to the reason why, the people have actually attributed it to the rising pressure from the US, on that note. Apart from, of course, negotiations were going on for years and ages, and this is where we have come down to eventually, that where India is trying to open up its market. There are going to be a lot of changes that we are going to see in our patent regime. As I said, that last week there were statements by government officials that we are looking to change certain provisions from the patent act. We're looking to introduce certain provisions with regard to data exclusivity. Again, nothing is there until and unless something is proposed or is out there in the before the public domain. But it looks like where the direction where the government is thinking about, the government is thinking of going. And the bigger issue that would arise from all of these things is, like, specifically if we talk about data exclusivity, which is starting from a position that India has agreed to for in its FTA with Switzerland, that it is going to impact the generic companies a lot, because they'll have to, what should I say? They'll have to redo their, they have to repeat the clinical trial exercise, which right now they just have to show bioequivalence. It is going to be, a lot of the companies might not be able to pay for the clinical trials, which is going to impact a lot on this generic industry that we have, and India's tag as the pharmacy of the world. So yeah, I mean, because of, you could see this domino effect in place, and eventually we can see a lot of changes being made in the Indian regime because of what we are negotiating and what we are asked to do during these FTA negotiations. Yeah.
That's great. So one more question I have with when it comes to foreign filings in India. So how do you see that in still in India, 80, 70 to 80% patent applications are being filed by foreign people? So what is your perspective on this, and where we are heading, and how we are going to encourage? Are there anything that government is doing on encouraging or increasing patents from industries, not from institutes? I can say institutes are doing pretty well, I can say. So anything that you want to add something on this, or you know that any work plan is done by
So, sir, I
government
mean,
on this?
from the annual report of past 2 years, I can see that there is a like there's an increase in number of filings by Indian applicants. So that issue that we see, that there are a higher number of foreign filings, we are, like, the Indian applicants are able to touch or meet that number. Like, they are giving, if I can say so, a tough run to
Institutes
the
are
foreign applicants.
really
Yes,
institutes are
that is the bigger that is
the
the
problem.
yeah, that is the bigger issue that we have to, like, focus on, is that the type of filings that are being done and by whom these filings are done. And when you're saying that what are the government efforts here, the one problem that I can see in this whole issue regime approach towards patent is that government is saying that you file a patent, you get a patent, and then in government institution, through NIRF rankings and everything, your institution is going to get a higher ranking. Your promotions are attached to the number of filings and number of patents that you have. without really understanding whether the institution or the person has the capacity to actually commercialize it. So people are filing left, right, and center, trying to get the numbers higher. We are celebrating that, all right, fine, India is granting these many patents or prosecuting these many patents in a particular year. But then ultimately, what about all of those patents? What is actually happening? Is it actually being commercialized in the country? Unfortunately, it doesn't seem like it, because merely filing a patent and getting a patent is not going to take you anywhere. You're a patent agent, you would understand that you know it is very important for you to have the capacity to actually commercialize it and make it available for public so that actually they can use it. So you just getting a patent and not really doing anything with it, or on an invention which nobody is actually going to commercialize it, and you being an institution do not have the skills to actually produce that particular product and introduce it in the market. So you would rely on licensees. Licensees are not interested because there is no market for them to do so. So ultimately, there is no innovation that is taking place. There is no benefit that anybody is getting out. So what we have to focus on, or what the government should be focusing on, and individuals like us who are working in this area, is that we need to focus more on what can be done to have patents which are being filed translate to commercialization.
Yeah,
Some sort of scheme, some sort of benefits that should be given to industries, which is again, giving some sort of assistance to the applicants who are not really able to do anything with that patent that they have gotten. One case, like a lot of case studies from US would show that a lot of these blockbuster drugs that are there and being sold by big pharma companies are actually the result of a patent filed by or worked together by the company
and
who
the
was
government.
providing the funding,
And the government.
and a government institution like a university.
Mm,
Humaira and all the other big
mm,
blockbuster drugs, these have been manufactured, like these have been invented by people who are coming from academia, who are coming from public grant institutions. So we have to understand this, that there needs to be, the focus needs to be on commercialization, not just getting super number of or like a higher number of patent registrations.
right, right, right. So as you mentioned, a good case where there is a collaboration or funding by the company to the institute, and then the patents have been filed. So if that can happen in India, where there is some restriction on collaboration and then filing a patent, maybe then industry can benefit a big time out of it. Otherwise, if the leniency is given to the institutes, even those fundings are given by government, right? So that's only the pain point, because I have seen last year I was just doing a research and I surprisingly found the top institutes, top 10 companies in top 10 applicants. These are institutes. Then I went down to few of the institutes. I don't want to name them. Uh, they had filed around 300, 400 patents, and out of those there was one common inventor for 300 patents. I was surprised, can a real person do it? And second problem is, now chat gpt is there, anyone can find thing. uh, Grant is maybe taken care at the time of grant, but this is also becoming a problem. And the most important is utilization of subsidies or funds that are being allocated by the government to these institutes, so that they can somewhere um, help in the growth journey of India, developing to develop the country. That's
No,
what
no,
my
sir, I
intention
completely
is.
agree with you. I mean, there are schemes which says that the government is going to help startups and educational institution to file a patent and assist them in all the charges that they'll incur during the patent prosecution stage. And although these initiatives are there, you also need to understand that the focus should be on what sorts of inventions are being applied for. Where does it make sense for government to fund a particular area where India is not in a position to to manufacture, produce
True.
that particular product? So for instance, uh, you know sectors or spaces where India is good in terms of manufacturing ability or industries, pharma sector being one, and then there are other manufacturing industries that are there, steel and aluminium industry being another one. You know, in when we talk about these institute, like these sectors, you would see that their patentees are people who are actually serious about patents, who are actually serious about
True.
business,
True.
right? But
True.
then most of the people who rely on government subsidies are filing patent because So one way or the other, something is connected to the number of patents that they file, whether they're being their promotion or some other benefit that they need to avail or they need to benefit from. So the focus, as you rightly pointed out, needs to be on how you are actually planning to commercialize this patent once you get it, and not merely
Right.
on filing and getting a patent number.
So, okay, okay, great, great, great. So it was good to know your also inputs on these kind of filings, and that is where we all are working towards making India a developed country to align our missions with our PM's missions in bits, small and possible, small and bit ways we are contributing. So thank you for giving your time. Do you have anything to add? Anything you want to add before we close the
No, sir.
show?
I mean,
Anything we have missed out? Anything you want to speak? Anything question? Any question you
yes,
want me to
no,
ask?
not exactly question, but
Yeah.
one point that I would like to add when we were talking about commercialization bit, we also need to understand, and this is somewhat connected to the part where we were talking about how the patent office should be operating.
Mm,
One thing that we
mm,
have seen is of late, after the IPAB was
mm,
abolished, and when the high
mm,
courts became the platform, or the institution, the organizations to file an appeal against a rejection order, we have seen that a lot of the high courts are saying that the orders which are passed by the patent officers are not reasoned, and then they would revert the matter back to the patent office, ask them to reconsider. Many a times we are seeing that, maybe to avoid any further embarrassment, if I can use that term, the patent office is simply granting the patent. We have seen this in a couple of cases. We have written about it on the blog as well,
mm,
where first, in a
mm,
5-page order, the patent office rejected a patent application. The applicant filed an appeal against it before the high court. The high court said that it doesn't make sense. The order is not reasoned. Please reverting the matter back to the patent office. They asked, please, reconsider it. And then, in a order which simply says 2 lines, saying that I have gone through the order of the high court, I agree that the patent should be granted. The Indian Patent Office granted the
mm,
application. Now the problem here is that
mm.
nobody is going to question these type of grants, because ultimately the patent office would be in a position where, if you reject an application, you will approach the high court. The high court is going to ask us to do all the things all over again, and we are in a position where we don't know what to do. And there is and the applicant is of course not going to go ahead and say like, "Arey, see what sort of order have they passed? They are anyways being granted a patent." So it's a so win-win situation for both these entities. But then ultimately, it's the public which is um, losing out here, because we don't really know what sort of patent are being granted, and these are the type of orders that are being granted. And until and unless some other company has an interest to file a revocation petition, and then go through the litigation and everything, nobody is going
But,
to care per se.
but
So people, institutions, organizations, in whatever capacity that they play a role, they need to take their roles and jobs seriously, if I can say so. They need to be more rigorous. They need to be more thorough with the work that they do. And yeah, I mean, that is something that I would like to
yeah,
add.
so to add to what you have shared, one experience, we also have similar kind of experiences where not only technicality, but there are also some egos that come into
I'm
a
sure.
picture
Yeah,
when we examiners. They are not neutral. They seem to be little variation in their attributes when it comes to handling different agents, companies, and so there is a need actually. It's a high time that we should have a need where we have a clear manual SOPs in place, so that even applicant, agent, or attorney want to refer back, they can refer to that particular SOP, and even examiners can refer to that SOP, and then they can have something where they can fight on. Now it's very different. Section 2 and J specifically, inventive step. No one is on the same page still. After so many years of establishment, we are still struggling to argue to the examiners or the controllers. You think it is obvious, prove it, it is obvious. You cannot reject a patent application because you think it is obvious. It's a basic thing that is lacking, I can say. So how to make this a form of SOP? Let's try to educate, contribute in some way to make sure that everyone benefits from
No,
this.
sir,
That's
that
what
is
I see.
absolutely true. To add on to that, back when we were working on this call for comments on different guidelines. So you would know that the patent office has different guidelines for different sorts of invention, pharmaceutical products, 3K. They have a computer related inventions के लिए guidelines, and general examination guidelines for patent application, trademark, copyright, GI, everything. So while we were working on comments for that, we came across a very interesting thing that used to happen in the UK, where they would have a platform where people could just say that, all right, when this development took place, this is how this particular thing was interpreted. And then they would send their comments, and all of these comments would be recorded in a public platform, which is run by the government body. So they would have access to all the recent interpretations of how a particular provision is being looked at. And if you would agree, since you are a patent agent, you could see that our patent manuals need revisions very frequently, but these revisions are not taking place as soon as they need to be revised, as much as they need to be revised. We are still relying on old versions of the case laws or interpretations, and things have been changing, very drastically every year. So we need some sort of guideline. You need some sort of SOP, that the term that you
Mhm.
used, where we could have all the
Mhm.
important interpretations by High Court and also by the Patent Office, so that an examiner who's new to the business, because we recently recruited so many examiners, I'm sure these officers are going to, need all the help that they are able to get. So they need to know what is the law, what is the position of the institutions in terms of interpreting these provisions, and that is something that is the need of the hour, and that the office should actually consider. And I think only the CRI guidelines was the one that the patent office came with, and this call for comments were invited like a couple of years back. I might be wrong, since I'm not really working on day to day basis, but that's what my understanding is, that there are still guidelines which are still being revised.
And also specifically, sometimes the controllers move out of patent law and ask something that is not relevant to what the prosecution should be. So that is also one of the problems. We got a lot of unnecessary questions, and we need to educate the controller that why you need it, and if you don't get it, what is going to happen, and how, your decisions. So it was wonderful talking to
No,
you,
sir,
actually.
same. I mean, to add on to that, at the beginning of my conversation, like at the beginning of my interview, podcast, whatever we can
Okay.
say, yeah, this
Okay.
conversation, I would say, at the beginning of the conversation, I did say that, when you are working with the government, it depends a lot on the type of people that you're working with. And the same thing, all the applicants can look at and can understand that, it is highly subjective, that how you end up dealing with what sort of officer, and how what all they may ask for. That lack of certainty is something which I'm sure is must be problematic for you as a patent agent, and also people who are, or inventors who are looking to get a patent on their invention.
Right, right.
So yeah, something should be done on that.
Yeah, so Spicy IP is definitely contributing on that. I see a lot of comments and suggestions coming on in the form of blogs as well. So, working professionals like us, we are trying to contribute something by having such kind of discussions and trying
That is
it. Yeah.
that is today what I can understand when I sit on the position of someone who's associated with the blog. Personally, I feel that Spicy IP is a platform that gives space for this healthy discourse on patent law and all the other IP laws, telling people who are, educating people about the basics of what IP is today, and also giving space to patent agents and lawyers to come and share their point of view, because collaboration is something which is the key for any field to flourish. As you said, like, collaboration is something that we need to focus on, and that is what our aim, or the blog seems to offer, tends to offer, aims to offer, that we need to have a more a platform where these healthy discourses can take place, so that eventually we can go ahead and build a rigorous and a robust IP regime for India.
Right. So am I correct? As democracy stands with the three pillars, with the three fundamentals: by the people, for the people, of the people. So by the people, that is how we want to. We should make and contribute to the change, I can say. So
Thank you so
thank
much,
you very
sir.
much for your time. It was wonderful, wonderful
Same
talking
here.
to
Same.
you. Got learned, and I hope a lot of not only IP fraternity, but you also discuss a lot of things that are beneficial for the trade and how they can take benefits. And definitely, it will be a good podcast to watch for all IP
Thank
fraternity,
you,
I can
sir.
say.
I hope for
Thank
the
you.
same as well.
Yes,
Thank
thank
you
you
so
very much
much,
for
sir.
giving
Thank
your
you so
time.
much for having me.
Yeah, so thank you, and
Thank you so much, sir.
yeah. So,
Yeah.
so if you have liked this podcast, don't forget to share it with the people who need it the most, specifically into IP fraternity or industries who need FTO informations on FTOs, how Indian government operates, and what are the benefits, and how patent office is going to change over the period of time. So keep inventing, keep investing, and keep earning tremendously. Thank you, and all the best.
Thank you. And also keep reading Spicy IP.
Yes, and always, it's a good platform. Always keep reading Spicy IP as a reference point for all your updates on IP, I can say. Thank you very much, and keep
Thank you, sir.
like, share, and subscribe to our channel. Thank you.